Good morning, everybody. Welcome to our webinar. Thanks for joining us. Today, we're going to be speaking about drafting facts in law sections of statements of case and formulating requests for relief. This is obviously a crucial aspect of counsel practice. It's probably right that more so say than litigation in Cyprus, for example, proceedings in arbitration are much more written than oral. But maybe Agis, our representative of Cyprus, will let us know. At any rate, it's a very crucial skill, and I think you're keen to hone that skill and to learn more about it. And this is an excellent opportunity to do so because we have some extraordinary speakers today. I will introduce them briefly, and I will tell you a bit about the format of how we propose to approach this webinar. And then we'll start right into it. Say already, though, that we are going to welcome your questions, which please post on the Q&A. So I think this is in no particular order, but here are our speakers, just as I have listed them. Dr. Natalia Gulyaeva is a partner at Hogan Lovells Dusseldorf office in their global regulatory and IP media and technology practice. So Natalia is very much specialized in technology. In fact, she's just been appointed to the WIPO Mediation and Arbitration Advisory Committee, which I think is very significant. It's based here in Geneva. So maybe we'll have the pleasure of seeing Natalia here in Geneva. Natalia has qualifications in, get this, England, Wales, Germany, and Russia, and she has a substantial business education. And not necessarily our second speaker, but the person I have listed here second is Christopher Chinn, who, like Natalia, is a fellow of the Chartered Institute. And Christopher is a Franco-American arbitrator and counsel. He's admitted in Paris, England and Wales, and New York. And Chris has run his own arbitration boutique law firm in Paris since 2017. Chris is a member, is vice chair of the European branch of the Chartered Institute of Arbitrators. We have also with us Agis Georgiades, who is also a fellow of the Chartered Institute of Arbitrators. So Agis is an advocate based in Nicosia with the law firm CGA, which is a medium-sized law firm specializing in litigation and arbitration. So Agis is, amongst other things, a member of the LCIA court, and he is has rights of audience between Cyprus's Supreme Court, and he is a member of the Cyprus Supreme Court's CPR Revision Committee. We have also with us Anna Gerdau de Borja, who is equally a member of a fellow of the Chartered Institute. She co-leads Track 5 of the task force dealing with corruption in international arbitration as a member of the ICC Commission. She is a former deputy chair of the Chartered Institute's Young Members Group Global Steering Committee. And aside from her PhD in Cambridge, she also has an LLM. She's admitted to the bars of Paris and Portugal, Porto, and she's registered with the Paris Bar. She practices international arbitration from the law firm de Raines Ganavi in Paris, or from Paris. We have Baptiste Rigaudeau with us also. Now, Baptiste has spent some time here in Geneva, as well as in Paris, where he now is, at his own law firm, Lead Up Advocates. He specializes in dispute avoidance and dispute resolution, focusing in particular on arbitration, both commercial and investment arbitration. He has a regional focus on Africa and Europe. He's admitted to the Paris and Geneva bars, the latter as an EU lawyer, and he has experience and training in both civilian and common law systems. We have also with us Alexander Leventhal, who is a partner at Quinn Emanuel in Paris. Alexander is a dual French US national, and he is qualified not just in the US and France, but also in England and Wales. So these are our distinguished speakers. Here is the format. There are going to be 9 self-contained presentations. Each is going to be led by one of our speakers. Then we're going to follow each of them up with panel discussion. And finally, we're going to tend to questions. We're going to answer any questions you have on each of those topics. So please post them in the Q&A. We have, let's say, an hour and a half, up to 2 hours. So we really ought to launch into this. I'll invite, therefore, Anna to begin on the topic of drafting pleadings and procedural rules. Anna.
Thank you very much, Philip and Christopher of the European branch for the invitation, and thanks to FCIArb for hosting this event. It's a great honor to participate in this webinar alongside such talented colleagues. Today I will discuss with you some key concepts for excelling in written advocacy in international arbitration, focusing on the importance to follow procedural rules established by the arbitration tribunal, often enshrined in Procedure Order Number 1. As you know, the Procedure Order Number 1 rules apply to written submissions set forth in the procedural calendar, which means after the request for arbitration and the answer to the request have been filed. I will focus on the ICC rules as most of my cases have been conducted under those. After Article 22.2 of the ICC rules provides that in order to ensure effective case management, after consulting the parties, the arbitral tribunal shall adopt such procedural measures as it considers appropriate, provided they are not contrary to any agreement of the parties. Such measures may include one or more of the case management techniques described in Appendix 4 to the rules. Appendix 4 to the ICC rules provides a few case management techniques that are at the disposal of the tribunal that will often discuss those with the parties during the case management conference that precedes normally the issuing of the Procedure Order Number 1. One possible case management technique is to require the parties to produce with their written memorials, with their submissions, the documents on which they rely. All documentary evidence will be produced with the memorials, including expert reports. Also, another case management technique that could be that could inspire some of the rules enshrined in Procedure Order Number 1 is to limit the length and scope of written submissions, and to seeking to avoid repetition and to maintain focus on key issues. Now I will move to examine rules under a typical ICC Procedure Order Number 1. There will be a section on written submissions in the Procedure Order Number 1, and that will sort of normally, very often is a bit, I'm speaking of like a model or standard Procedure Order Number 1 that is very common in international arbitration in ICC under the ICC rules. So one of the rules, like, is a bit basic, but it's very important, that the paragraphs are numbered consecutively, and that the submissions include the table of contents. And for each of the submissions, the parties will clearly indicate the evidence they invoke in support of their arguments, documents, expert reports, witness statements, and all these documentary evidence will be annexed, produced as annexes or exhibits to the written submission. So with the written submission. And then there are other rules common to Procedure Order Number rules that not always appear, but sometimes they do, such as the rule that submissions in reply or rejoinder, so in the second round of written memorials, shall be limited to rebutting the other side's arguments or statements. So one cannot raise new argument, one has to rebut because the second round. So this is quite useful because it ensures some predictability in the cases. So during a case management conference, counsel can even propose that for the tribunal, and the tribunal will decide whether to include like a rule such as this in the Procedure Order Number 1, remembering always that a Procedure Order Number 1 is a decision of the arbitral tribunal. It's not an agreement. Like the terms of reference under the ICC rules is agreed with the parties sign it. But Procedure Order Number 1 is a decision. So the parties can propose, they will discuss, and then the tribunal will decide whether to incorporate a rule like this. And also, a very typical rule that's quite very useful to ensure predictability is that after submission of a party's final memorial on the merits, a party shall not be allowed to present new documentary or other evidence unless it submits a reasoned request to the arbitral tribunal showing that it had without fault, no possibility or reason to offer before such evidence, and then the tribunal will decide. There will be also another section on documentary evidence specifically, and we'll sort of perhaps recall the rule that I already mentioned, that written submission shall be accompanied by documentary evidence and testimonial evidence relied on by each party, including legal authorities. And there will be rules on how to present the exhibits. There will be, for instance, searchable PDFs, there will be numbered. It's a bit basic, but it's very important to help also to make the task of opposite counsel easier when they're rebutting and responding to the arguments. Also for the tribunal, when they will be deciding on the case, that some of these rules, the formalities are complied with. Also, there will be a section on evidence of fact witnesses, which means that often in international arbitration, in most cases, there will be written witness statements produced and with the written memorials, and these witness statements also, when they refer to documentary evidence, they will also make references to it, the exact number and the paragraphs and the page number, so that the one can easily follow and understand the evidence that is presented in support for statements of the witness. And as you know, witness statements will require often the help of counsel to draft. Obviously, it's the witness statement, but counsel will help, especially with the cross-referencing for the exhibits, etc. Also, one thing to recall is that often in international arbitration, the rule for witness statements, there will be rules under Procedure Order Number 1, inspired by Article 4 of the IBA rules on the taking of evidence of international arbitration, which means that the witness statements presented with the written memorials will contain, for instance, an affirmation of the truth of the statement. And that's very important, that be signed, be dated, and every time the witness refers to documents, there will be citations to the exact document number and paragraph and pages to help to make life easier. Also, the same applies to expert witness, to the extent it's used in a given proceeding. It's not always that there is need for expert evidence, and there will be often rules under Procedure number 1, inspired also in Article 5 of the IBA rules, such as that the expert report will include a description of the instructions it received from counsel and a statement of his or her independence from the parties. I should make a little parenthesis here. This is very common in international arbitration. I'm also qualified in Brazil, and in Brazil, for domestic proceedings, it's not very typical to have independent party-appointed experts, which means that they don't often will include in their in their expert report a statement of independence, because they're supposed to be sort of partial. It comes from civil procedure in Brazil, and it's very typical to have for this reason, tribunal-appointed experts. This is very typical of Brazilian domestic proceedings, which lead to many inefficiencies. But that is another discussion. So in international arbitration, normally the party-appointed expert is supposed to be independent. So that will, and the document, the expert report accompanying the written memorial should include this statement of independence. There will be also another section on translations. That's also very important. Given, let's say, the language of the arbitration is English, then one cannot produce documents that are not translated, because the arbitral tribunal will have to, and the opposite counsel sometimes will not understand the language. So there should be translations, and so exhibits should be translated into the language of the proceedings, and the party producing those documents that are not in English, let's say in the case the language is English, they will also produce the translation. If a document is very long, there will be a rule also, often in Procedure Order Number 1, stating that one doesn't have to translate a whole 100-page document. One just translates the excerpts needed in the context, and giving a little context for one to understand the translation, and also making sure the page numbering is the same as from the original document. Some they seem a bit basic, but they are of immense value to ensure effectiveness and saving time and costs. So this is a bit of formalities. I end here for now, but I'm sure my colleagues will have other comments. Thank you.
Thanks, Anna. That was very complete. And I do invite comments, discussion from the panelists. Please begin, anybody who wants to start.
Well, if I could start by making a comment, one matter which is very important to ascertain at this stage is what style and what format will be adopted for the pleadings. It is sometimes assumed that everybody involved in the case will be following the same practices we do, but that's not the case very often, because it may be that the other lawyers or the tribunal members involved are accustomed to a very different way of drafting pleadings. Of course, the key difference that I have in mind is the difference between a pleading in the common law sense and the memorial in the, let's say, the civil jurisdiction style, which can be very, very different, both in content, detail, and in style. So when faced with an international case, one should try to solve these matters as early as possible to avoid having, at a later stage, pleadings which are very, very differently styled from one side to the other. So yes, this is a very crucial point, I think, and it cannot be easily corrected at a later stage. So it should be dealt with before, probably before the first procedural order is issued.
Okay, thanks, Agis. Anna, did you want to respond?
Yes, I agree. I think it's very important to discuss this at the case management conference before procedure number 1 is issued. I agree with Agis. And perhaps to explain a little bit what I see in international proceedings in ICC, for instance, in ICC cases, is that there's been an attempt to reconcile civil law and common law traditions. Common law traditions traditionally focusing on the oral pleadings at the hearing, whereas civil law tradition focus more on the written memorials. And the hearing is not that important in the civil procedure. In many countries, not all countries. So we cannot generalize civil law. There are many variations within the civil law tradition, But in any case, international arbitration, they try to reconcile, which means that we have a very extensive, often memorials, and combined with the very long hearing. So it's a bit of there's a lot of repetition, and this is explained by the attempt to reconcile those different traditions.
Okay, thanks, Anna. Anybody want to react, ask something further, introduce other issues?
Probably just to raise the importance of deadlines which are being agreed in the procedural documents, simply because while the tribunal does set the schedule, the parties, the counsels to the parties have to take a very active role in the procedure when the deadlines are set. Because each case is different and the complexity of the case is very important for the success of the parties, and therefore the councils should really negotiate a reasonable time frame for each step.
Yeah, absolutely crucial. Yeah.
I was
Usually,
going to say, usually it's worthwhile to in an early stage of the proceeding, before the procedural order, the first one has been issued, for the counsel for both parties to get together and to see if they can come to any agreements. That may not be possible in every case, but certainly not only does the tribunal appreciate it, but I think it makes the counsel's work easier too when you have a common agreement between the parties. Or at least there's not an agreement, so then you know what to raise before the arbitral tribunal as a question.
yeah, I think that's absolutely important because as Anna mentioned, at the end of the day, the procedural order is going to be determined by the arbitral tribunal, so they really need to consult. And a lot of the rules will say they have to consult. On this issue, what do you think about this? Is there anything that ought to go into something like the terms of reference if you're in an ICC arbitration for the reason that the parties have a virtual veto over its contents, or more power, let's say. At the end of the day, it's probably right. The ICC court will just sign the terms of reference if the parties don't all sign. But is there anything that's so important procedurally in relation to the pleadings that you'd want to see in the terms of reference and not in the procedural order, because the parties have more control over it?
Well, if I could just say, I mean, there are the obvious example that comes to my mind is, which doesn't happen very often, of course, is when we have a documents-only arbitration. Maybe it's a good idea if you see from the beginning that the facts are not really contested. It's just a matter about interpreting the contract or ascertaining what is the what should be the expert position on a matter. And maybe just by reviewing the documents, that is enough. So if that is agreed, then it can be included in the terms of reference. And it may also be useful to actually attach or even refer and adopt guidelines. For example, the Chartered Institute's guidelines for documents-only cases. So that's the obvious example that comes to my mind, but it's not the only example. It may be the case, for example, that when we have some form of expedited procedure, or when we have people who are in geographically very distant places, and we want to make sure that there will be no adjournment of the hearing, that we may want to include some procedural matters in the terms of reference to, let's say, to lock certain matters and leave the rest to be determined by the tribunal at a later stage. So it can be useful, even though it is something that we should be very careful at being over-regulating from the beginning. And it's also usually a matter of time because there are too many things to be agreed at the terms of reference stage. So the tribunal will probably say, if there are too many things contested about the procedure, we'll just decide this later. So I think that's how it works.
Yeah, I think that's a very complete answer. If there's no fierce opposition, I propose we move on to the next discussion topic, because we do have a very course of material, and I think it's now open for me to do so. So our second topic is obtaining information about the facts of the case in order to prepare the pleadings, and it's going to be Baptiste Rigaudeau who will take the lead on this. Baptiste, please let us have your thoughts.
Thank you, Philip. Can you confirm that you hear me well? Yes, fabulous. That's the first step. Yes, so well, first of all, I need to thank the European branch, and especially Philip and Chris, for inviting me to share the experience, my experience on that topic. You'll see me again at other such webinars, so I hope to make a good impression at this first one. But so before I give some of the tips to do a good job at collecting the necessary facts to be your case, I'd like to make a quick sidestep and talk about the importance of the request for arbitration and its link to the statement of claim. And that comes from very actual experience, because in some instances and under certain rules, for example, the LCIA rules, when there's a defaulting party, for example, the claimant can choose to have its request for arbitration treated as its statement of claim. And that choice can be obviously more cost effective. But if your case falls under that scenario and you're thinking about electing that your RFA is treated as your statement of claim, you must be extra sure that your case is properly made out in your request for arbitration. And you must be 100% sure that the tribunal won't need additional evidence to decide. You need to provide in your request for arbitration enough evidence to establish the tribunal's jurisdiction. So, and that goes without saying, but it's better said, as we say in French. You need to have enough evidence about the making of the contract, about the parties' consent to arbitration. You need to provide enough evidence about the obligations of the parties. And of course, you need enough evidence as to the quantum of the claim. So for example, if the claim is about non-payment of invoices, you obviously need to have a complete set of invoices that you are claiming have not been paid. So, so it means that you need to do your homework as to the facts of the case, not at the statement of claim stage, but rather I would argue much earlier on. So that being said, that's a good segue as to how you actually get that information. How do you collect that evidence? So you're getting a sense now that I think it takes a lot of time. And so you need to start as soon as possible. In my experience, it's a very intellectually challenging exercise where you can indulge yourself in fulfilling your dream of becoming a private detective. So you'll generally start with receiving some documents about the case once you're instructed. And maybe you'll also receive a sort of summary of the facts, which is prepared by your client or most often the in-house counsel at your client. At this point, I would advise to be very careful not to take anything for granted in this type of summaries. I've had the painful experience of relying too heavily on that type of document because there was little other evidence we could rely on. And of course, we always say clients are your worst enemy because they tend to lie to you. And it's not a bad faith lie, of course, but the clients tend to convince themselves that they're right. The employees think they're right too, but the documentary evidence would tell you a more nuanced story. So those summary of evidence, you might think, great, they've done my job for me, the clients, but take it as a grain of salt. You must go on your fact-finding mission by yourself, talking to people in the organization, those people that are identified in the first documents you receive. And from those conversations, you identify other people that you might know about the case and you want also to talk to those. Again, that exercise is really important in my experience, but it takes a lot of preparation and time. So obviously you need to tell your client that this costs money. It's not only an occasion to learn more about the story and the case from the people who are involved in it, but it's also a way to identify potentially future witnesses. People that are good at expressing their memories. You don't want their views, you want their memories. And people that are also confident enough to be challenged on their recollection of events. Skipping that exercise or doing it summarily to save cost is a bad idea in my view, because you will learn about your case, your client, and the other side. And it will save you time, cost, and stressful moments down the road. Likewise, and that's a really important point, I think, it will make it easier for you as a lawyer to think of settlement options, because you will learn about the factual, but also the relational background between your client and the other side. Now, if we focus on documents and not recollection, oral recollection, where do you find the documents other than those you have received willingly by your client? That's an interesting question, because you would probably say, can I find any document outside of my clients? So first, let's start with asking your client, and you must ask your client to provide as many documents as possible. You don't want to ask or to formulate requests which are too wide to your client, because in my experience, often those fall through the cracks. So you want to make very specific document requests to your client, just as you would do actually to an arbitral tribunal. And you want to chase And that's also very important. You want to chase your client about those documents as often as possible, because your nightmare is to be on the edge of filing a statement of claim and missing that document and realizing that you made the request for that document 2, 3, 4 weeks ago and it fell through the cracks. Then if possible, you can go on site to look for documents. You can also go to your client's offices to conduct additional interviews. That sort of exercise, in my experience, generally yields good results, but you need to be conversant in USB keys and online storage platforms to be as efficient as possible. Now, as to documents which are not in your client's possession, I'll just say that there are possibilities to request interim measures from local judges before the constitution of the tribunal to preserve and obtain evidence, including in the hands of third parties. But in France, for example, the documents seized further to that kind of procedure will be consigned into the bailiff's hands, and they cannot be used until a certain amount of time has passed. The next issue I wanted to touch upon is the issue of experts and their relationship with facts. They can also be the ones to provide factual information on the case. You never know, the experts may be engaged before the lawyers, especially in construction cases. They might be assisting the client to put together a claim, for example. And I'm thinking of delay and disruption experts, for example. So it's important to understand before obviously writing the statement of claim, but quite early on, who's working with your client when you get involved, and because these people may be an important asset in collecting information. You want to meet with the experts if they have been instructed before you. You want to learn about their view of the case and challenge them about this view if need be. They can be also, again, great assets in settlement discussions because they can provide technical and financial solutions to suggest to the other side to ease up a settlement rather than the solutions you can come up with yourself, which are mostly legal solutions. Lastly, before I conclude on this topic, a very concrete point as far as organizing these elements, which I just talked about, documents, and then also notes of meetings, etc. I would recommend using a software called Exhibit Manager, which is a bit pricey, but it's very, very good. And it allows you to organize and review documents at the same time in the same database on the same platform. So unless there are questions on that topic, I'm sure there are, I can turn to obtaining information on the law of the case, Phillip.
Thanks very much, Baptiste. Would you mind putting in the chat the name of that software? If you have a moment, not now probably, because I didn't quite get it. It sounds like
It's called Exhibit Manager.
Exhibit Manager. Okay.
Yeah.
Okay. Sounds very useful indeed. Right. Panelists, any reflections on what Baptiste has just told us? Very practical advice. Thanks, Baptiste.
And maybe just to mention to our audience, since Baptiste mentioned very important element, right? That sometimes the information provided by the clients is not entirely correct. And here, there is a very interesting report, just if the audience is not aware of it, by ICC on maximizing probative value of witness evidence. There has been a respective group established by ICC, and I followed very closely the report and the work of the group. And it's very, very interesting interesting document to read. You will be able to find it on the ICC website or request from ICC, but it shows how actually some human beings not being willing to provide incorrect information have already convinced themselves that this is exactly what was happening, and how we as arbitrators or counsels to the parties have to react and simply protect this information in the very beginning of the proceedings to get the most relevant and most correct information from the parties and witnesses.
100% agree, Natalia. I think that's one of the most difficult things to do, is to identify where a whole organization has convinced itself of a story against what actually happened. I'll give you a very concrete example. I had a case recently where I was counsel for one of the parties. The case was about a warehouse which had burnt down, right? So most of the evidence of what happened actually couldn't be found because everything was in rubble. And the client and most of the people, except the insurance counsel within the organization, had convinced themselves that they were right and that they did everything by the books, etc. Probably because nobody, and that's not blaming your client. I mean, everybody has their reasons, but because nobody wanted to be held accountable for screwing up, right? And it took quite a lot of those interviews, and they take time, and your client is going to sometimes complain about how much time you spend on those interviews. But it took a lot of interviews to get to the bottom of things, and not actually get to what had happened, because you couldn't know, obviously because the fire had happened, but to get a sense that people were actually not telling the truth, or the exact truth, if that's even a phrase. And once we got to the bottom of things, or at least we had a better feel that we might have been led in the wrong direction through that first summary of documents. It changed obviously quite drastically the strategy of the case, and we got to a settlement with the other side, and which was pretty harmless to the client anyway, because they were insured for most of the damage. So maybe that the lessons I learned on that, if your organization is and your client's organization is big enough to have an insurance lawyer in there, and they've been involved in some of the claims after the event, spare yourself, some stressful moments, and indulge yourself in an hour conversation with that guy or that lady, because they probably have, an objective perspective on the events, a more objective one than the operationals on the ground.
Okay, well, thank you, Baptiste. Let's move on to
Wait,
Baptiste.
Philip, we have a bunch of questions actually.
Yeah, as for the question, yeah, I was thinking it would probably be best to answer the two outstanding questions over the chat, but I would invite Alexander to consider addressing Lila's question, which has to do with the request for arbitration. I was just doing that for a number of reasons. First of all, they're not specifically on the topic of gathering the factual evidence. And I invite any of the panelists to answer the questions in writing, the current ones.
Yeah, I'll answer the Atina's question once I'm done with my presentation.
Yeah, okay, that's probably best. I hope that's agreeable to our attendees. We do have a sort of very full program, and we want to focus on the topics because we feel that our mission is really to impart the most amount of practical information to you in the limited time we have. So if there are strenuous objections, please don't hold back in the Q&A. And certainly do continue to ask questions. Baptiste, gathering material about the law before you put pen to paper.
So in my experience, so obtaining information about the law of the case is a bit less time consuming because generally the law is a less moving part than the factual matrix of the case. And that's, of course, a statement which is much truer in commercial arbitration than in investor-state arbitration, because as we all know, investor-state arbitration is an ever-moving part of the arbitration world. So the first question, however, is to ascertain the law applicable to the case. I must confess that I've never had an arbitration with no applicable law, or where the arbitrator must decide ex equo et bono. I'm sure my fellow panelists have had that experience, and I'd be happy to hear about it. But often it's true that the question of which law is applicable is the big debate in the first exchanges of submissions. That's typically an issue which the arbitrator can deal with on a summary basis, on a preliminary basis. So in my experience, that's a good way to deal with it, because it's one less aspect which the parties will have to brief extensively in all their submissions. Once the law applicable to the merits of the case is decided, or once the arbitrator has at least set the confines of which law you should be arguing pursuant to, then you can organize yourself to find out more about this law. I'll give you a concrete example. Again, I recently had a case where I acted as counsel and the parties in the contract had chosen UNIDROIT principles to apply. And one party also had argued that the DRC law, so the Democratic Republic of Congo law, also applied because the events occurred in the DRC. And so the arbitrator ended up, I think correctly, deciding that UNIDROIT principles took precedence, but in the silence of these principles, DRC law would apply. Now, it's easy to research certain laws which are well documented with databases, etc., and search engines. But the corollary is that some laws are really tough to research because there's no website which compiles all the sources, case law, literature, and books. So I would advise that it's important to get in touch with local lawyers to assist, or lawyers which at least have some sense of the law of the country. And of course, if it's a civil law system applicable, contact a French lawyer. Contacting a lawyer, a local lawyer, at least will give you an idea of some of the peculiarities of the system. And in my experience, these exchanges, these discussions, lawyer to lawyer, are quite useful to better assess whether you need a legal expert. Because, as was mentioned by Anna, legal experts need to be guided by a set of instructions. Typically, that set of instruction will be in the form of questions. It'll be, does X law allow for such remedy, specific performance, for example? And if so, what are the conditions to be met to seek specific performance? So again, you need to have a sense of the legal issues at stake before contacting candidates for legal expert. You don't want to go and ask a professor of insurance law about a purely commercial law or purely corporate law issue. Although, in my experience, professors tend to say they can speak on anything and they can write on anything, but it's better to have that professor of law specialized on this issue. Now, these legal experts, you don't want them to engage too much on with the facts, but on the other hand, it's important that your questions and your instructions produce answers which are relevant to your case and that you can use in your pleadings. I'm saying that because an expert that takes too much of a view on the facts or that does not set out clearly his or her instructions will be susceptible to be cross-examined on the facts. And let's be clear, this is a bad scenario for your case, because an expert can never know the facts as well as counsel. So you need to be careful about how the instructions are formulated in the expert report, because this is the shield for your expert in cross-examination. So the selection of these experts can be tricky in some countries because there are not many experts that have experience in testifying before arbitral tribunals and that know the area of law you will have to argue. So again, your network is extremely important to get feedback on potential candidates and to make sure that they're not conflicted. So I would recommend not hesitating one bit to ask people in your network about their experience and feedback on a specific candidate. The last issue I wanted to touch upon on this topic is how to integrate all these different legal sources that you've researched and obtained into your pleadings. This is also a basic one, but you integrate them into your submissions as legal authorities, and you file them with your pleadings and also with the legal expert reports if there is one. On this point, I would advise to check the legal authorities cited by your experts very carefully to avoid mistakes or surprises. Interestingly, it can sometimes happen that you have diverging views on legal points with your experts. So better know and fix those diverging views before the report is filed. And before it's filed, it goes without saying that you need to make sure the expert report can be used by the tribunal. So it has to be relevant, it has to be well-structured, well-written, and concise. Your expert's report is not a PhD or a master's thesis. So it's okay, and it's actually encouraged to have constant back and forth with your legal expert to make sure they stay on track, to make sure they address your questions, and that they produce an expert report, which doesn't need to be fully rewritten on the day of the filing. Also, and this is my last point, be conscious that once you file your expert report or reports, they will stand as evidence in chief for your experts, and they will be cross-examined on that basis. So you need to make sure that your expert has written their reports. I'm saying that you might think, well, that goes without saying, but let me tell you that I have had a few hearings where the other side's experts agreed with the question, or rather confessed that they had not written their report, but rather somebody in their team did. And that's not a bad look for your expert or the other side expert when that happens at a hearing. So make sure they've written their report, that they know it inside out, they're comfortable citing it, and you are comfortable putting it forward. So I'm happy to take questions on any of these points now or later if you need more time to think of a tricky question for me.
Thanks, Baptiste. I think Chris wants to intervene at this stage. Chris.
No, I just have a quick practice tip to add on to what Baptiste has said. Even in what might be termed simple cases, where you're looking at the contract and it's a breach of contract case, oftentimes it's good to remember to cite the governing law in your arguments as to how should the tribunal interpret the contract. Sometimes it's not always evident that simply by citing provisions of the contract, you're even conforming to the governing law, because who says that you should follow what the contract says, as opposed to what the party's intent was, as opposed to what good faith is, and what is the burden of proof when you're arguing. These are very basic principles under the governing law of an arbitration that oftentimes can win or lose a case on a particular question. For instance, if you're claiming damages as a consequence of breach of the contract, and the contract does not stipulate what the consequences of the breach are, then oftentimes you have to go to the governing law to claim damages. Well, if you just cite the contract, to the tribunal and say, oh, and this is a direct cause of the breach, and so therefore I'm claiming damages. Oftentimes that's not enough, because how does a tribunal know what the measure of damages is under the governing law? How does a tribunal read the contract terms? Should it infer terms that are not there in the contract? And keep in mind that although the tribunal may be qualified in the governing law of the arbitration, oftentimes the tribunal cannot step in and offer to solve a party's problems and say, oh, well, I know that the law of damages under English law is X, and therefore in the final award, I'm going to apply English law, because that may be unfair to the other party, if a provision in the law is not argued during the proceedings. So, it doesn't take that much legal research, but you should, when you can, provide the basic structure of reading the contract so that the tribunal knows, what to do if the plain wording of the contract doesn't apply.
Thanks, Chris. I think we need to move on, although there's much more to say, to a topic that Chris is going to be dealing with, which is general drafting tips. Chris?
Yeah, and this will be a bit easy for me because I'm basically going into just a bit more detail into what Anna said in her opening, where she talked about structuring your written submissions. And I guess the first point is that, well, it depends on who your audience is, right? So you want to, different arbitrators and different tribunals appreciate different types of structures of pleadings. So when you can, I mean, obviously the claimant's initial request for arbitration, and which is in some cases a statement of claim, will be written in a style that the arbitral tribunal may not appreciate, because it's made before the tribunal is constituted. But once the tribunal is constituted, you should check with the tribunal to make sure that what you're writing to the tribunal will satisfy what the tribunal's needs are. What does it want? So in terms of structuring pleadings, I think oftentimes it helps to have headings for different subjects. So, sometimes you get a big mess of an argument where there are legal arguments, legal principles, facts, and appeals to equity, and it's just one big argument. But it can help an arbitral tribunal to find, what are the legal bases, what is the governing law, what is, what are the damages resulting from the breach. All of these different items can be separated in pleadings. So that's often, and the degree to which they're separated depends on, what you think will persuade your particular tribunal. I'll be talking about structure of pleadings, some formatting tips, and foreign language materials. So when you structure your pleadings, as Anna said, it's oftentimes, if it's any longer than, say, 2 or 3 pages, then a table of contents is usually helpful. That way the tribunal knows where to look, and when it's writing its award, also it knows where to look to see what your arguments have been. Numbered paragraphs are helpful too, so that when the tribunal is referring to a particular argument of a party in its award, then it can cite to those numbered paragraphs. Different memorials might have different structures. So drafting a request for arbitration is usually very different than drafting a statement of claim. As a practice tip, seasoned practitioners will know that it's often unnecessary to put additional detail in a request for arbitration, because a tactic that parties use, which can be helpful, is they put the basics for their claim out there, and then you wait to see what the other side has to say in response, and then you can, in your responding pleading, you can offer more detail. So it may not be useful to show all your hands at once. At the same time, the request for arbitration may be the first document that's looked at by the tribunal. So it has to be strong, but not necessarily fully complete, because you may not want to show all of your hands in your first pleading. It's a depends on the strategy of the case. And of course, a statement of claim will usually be more detailed. Clear separation of ideas. Also, there should be 1 or 2 citations for every legal principle that you state or a factual assertion. So, I mean, and this doesn't have to be carried on throughout your written pleadings, but the first time that you state a key fact, or the first time that you state a key legal principle, cite either in parentheses in the text itself, or make a footnote and cite it, because everything you say has to be supported. The tribunal cannot, oftentimes, is not, it's not enough to state your argument. You have to support it too. And it's really your citations and your footnotes that provide the armament for your arguments. You might have this great story about how your client was mistreated, et cetera, but if there are no citations to it, then it's basically empty. The tribunal cannot take your word for it as counsel. If you say French law, it's a general principle of French law that there should be good faith in a contract. It's not enough just to say that. You have to cite to a footnote so that the tribunal can then, in its award, rely on something that's concrete. So that's something that's some comments on the basic structure. In terms of formatting, it shouldn't really matter what formatting conventions you use, but just stick to them. So if you're writing in English and you're writing Mr. and Mrs., sometimes in English they don't have the dots, right? And sometimes they do have the dots. So it's like Mr. dot X. All these little conventions, it doesn't really matter in international arbitration what grammatical conventions you use, but whatever you use, be consistent and stick with it. If you're working with a team of drafters, decide on if you're using Côte d'Ivoire French or French. What language exactly are you using? Are you using British English? Are you using Australian English? Are you using American English? Just decide what you're going to do and then stick to that. In terms of cross-referencing within the submission, so if you're writing your first draft of your writing, you're saying, as we stated in statement of facts at paragraph X. I'm not a big fan of having detailed cross-references within a document, because then that leaves a lot of work for you later, and the structure of briefs can always change. So it may be better just to refer to a citation generally. And certainly if you have a citation like to a legal principle, a legal decision, or to a factual decision, it's better that the author of whoever's writing the submission writes that citation out, or is in charge of putting that in when the submission is completed. So what am I talking about? I'm talking about where maybe a partner in a law firm is writing an argument out and leaves a lot of blanks for their junior or their intern to fill in later. That's not a good way to draft. It's not a good way of writing. Whoever is thinking about the idea and thinking about the citation should be responsible for putting that citation in. Otherwise, if an intern is going to fill in all your citations at the last moment, then they may not know exactly what you meant when you were citing to that legal source or to that fact. So it really should be whoever's authoring the first draft of a submission should be either in charge of putting the citations in later, or you should just put it in your initial draft. With respect to quotations, block quotations are usually acceptable to arbitral tribunals, and it's helpful for them because they can cut and paste from your opinion. Well, the tribunal should check to the original materials, but they can cut and paste from your pleadings as well. And it's good that you give out the entire, or at least a selection of what the source says. Having said that, citing just quotations to either the law or to the facts without any argument or commentary or context is usually not persuasive. So in other words, I've seen parties where in the legal section of their submissions, they just cite certain sections of the civil code and they say, oh, this is relevant to this case. That doesn't really help anybody because you don't know how it's relevant to the case. So at least make some comment about why the citation you're using, why you're using it. And then finally, with respect to foreign language materials, you want to make sure that if it's not in the language of the arbitration, that key excerpts are translated. And in many procedural orders nowadays, tribunals generally allow for free translation without any certified translation and only of key passages of arguments. And if there's a debate between the parties as to what a translation, how a text should be translated, then you may want to have a certified translator step in. And that's just about all I have now in terms of general drafting techniques. I think the main takeaway is you have to be sensitive to whoever your audience is and make sure that the conventions such as having excerpts of foreign languages translated or not, and if it's a free translation, and even structure of submissions, page lengths, etc. All of this should be discussed with the arbitral tribunal so that you know that you're satisfying your audience. Because at the end of the day, different people like different ways of presenting evidence and arguments, and you just want to connect with your audience, which is the arbitral tribunal.
Thanks, Chris.
And I guess there's one question by Rizky.
Yeah, may I interpret that question, Rizky?
Yeah, sure thing.
Yeah. So Rizky is asking whether in drafting pleadings one should stick to the pure facts and law in an unemotional way, or whether rather one should temper that with accounts to the fact that every arbitral tribunal has feelings and has sensitivities. So what do you think? Strictly objective, spare, factual and legal treatment, or a little more, to try to massage the message? Crucial question in advocacy.
I
think it doesn't hurt to put in some emotion, but you always want to support what you're saying with the law and the facts, but there's also a place for storytelling as well. So and I've seen that being done. But if you're going to tell a story, then it better be, you can't just say that they were not acting in good faith. Then you have to go on and say, and the law, by the way, supports my interpretation of what's happening.
I mean, I would again ask who your tribunal is, because Swiss arbitrators, and I'm sure Phillip, you would agree, some Swiss arbitrators are not really interested in any emotions in your pleadings, to say the least. But I've been, I've also practiced in the US, and in some instances, US counsel will be very, it's not really emotions, but it's more the tone you use, the style. The style will be very aggressive. The problem is when you have too much of an aggressive style, you quickly become identified as the guy who's shouting and the guy who just sees strategies and plots and complotisme, as we say in French, everywhere, which can be not in your client's advantage, not to your client's advantage. But I agree certainly with Chris that the best pleadings you read as arbitrator are the ones which are not boring. And so that means telling a story, indeed, using analogies when you can and when they don't fire back, and putting the arguments into a way which doesn't let your arbitrator, doesn't let the pleadings fall off their hands. And that's where our added value, I guess, is.
Yeah, I absolutely agree. I think one should be very limited in the amount of emotional material one adds. I was watching this podcast by Stephen King. He writes all those horror novels, and his view was that one really ought not to use adjectives, or one should use very, very few adjectives and to choose them very carefully. And I do find that when I'm reading pleadings as opposite counsel or as an arbitrator, when I see things like atrocious or horrendous or grisly, I tend to think, oh dear, this is actually a bit of a crutch, isn't it? It's propping up something that perhaps couldn't stand on its own. So I think one should be careful about that. I think it's a question of moderation. I think the most important thing is to be really reliable in what you say. For example, if you quote something and you misquote it, or you obviously leave out something that follows that's going to totally contradict it. I think that does tend to erode your credibility as an advocate. So using this kind of emotion, it tends to undermine the credibility, in my opinion. But there is a place
I
for.
may even play against you, I think, because the arbitrator may consider it as a sign of weakness that you are lacking evidence and you are trying to include emotions. Absolutely,
yeah. That said, all arbitrators, and Chris's point is you need to know your audience are human beings, and the psychological world is absolute reality, as everybody knows, in our sophisticated modern world. In my earlier career, I was in a family case where my client had cheated on his wife. It was a divorce case. And in Swiss law, this actually doesn't matter. It legally, I should say. And anyhow, it did affect the result, in my opinion. The judge started instructing him on, proper conduct. And I thought to myself, oh dear. And I said to myself, I could have added stuff about the other side, and I didn't, because I wanted to stick to the law. And I really asked myself whether I ought to have, kind of fought fire with fire. Just so you know, it's, I guess, a matter of impression, knowing your tribunal, keeping things sensible and not extreme. Anybody want to add anything on this topic, or should we move on to the next one? Notably, in view of the scarcity of time. I see you nodding. Let's move on. So we're now moving right on to the pleadings themselves, and Alexander will please let us know about the initial exchange of pleadings in an international arbitration. Alexander.
Sure. Perhaps just one last word on the last point. I think the tone that one takes is it's important to keep in mind not only the tribunal but also your case, because in certain cases it may be appropriate to signal to the tribunal that what's going on is not just business as usual, which perhaps leads into the question of what you say first, an initial exchange of pleadings. And I think that when you ask someone, what do you need to include in the initial exchange of pleadings, it's a bit of a Rorschach test of what you think how you think the arbitration should take place. And I think there are two sort of tiers to that. The first is a cultural one, and a second is a strategic one. The cultural one is that the initial exchange of pleadings means different things depending on whether you're a common law and particularly an English trained lawyer versus without perhaps as much experience in international / continental arbitration versus a true sort of internationalist or civil trained lawyer. In the common law, in arbitrations that follow more of a common law procedure, you tend to see pleadings that are drafted at the beginning of the arbitration, where parties will lay out their entire case and the evidence will follow. that is a unique circumstance that requires a bit of getting used to when you're not deeply involved in that type of system. Generally, one tries to be as broad as possible while at the same time being as specific as possible. You have to, if you want to change your theory of the case or even certain aspects of your pleadings, you will have to apply at a later stage to amend the pleadings. So you want to be as broad, but also to tell a story at the same time, which is indeed a challenge. And in responding to that initial pleading, generally speaking, parties tend to simply deny or affirm facts and not put on their own story, which is quite different from the approach that is taken in international arbitration, where the request for arbitration is really serves the purpose of informing the other side exactly what the dispute is about, what the claims are, and also informing the tribunal and the institution, because the idea is the tribunal and the parties are going to set the procedure together. So you have to know exactly what this case is about before doing that. But strictly speaking, the initial pleadings, for arbitration and the answer are not the pleadings on the merits. So they're not the pleadings that you're going to, or submissions that you're going to expect to see witness evidence filed with, or expert evidence, or, for example, all of the documentary evidence. So your strategy in this case will depend really, your approach to the request for arbitration will really depend on what you want to achieve in the case, and particularly with the request for arbitration. It may be that the request for arbitration is a vehicle for achieving some sort of settlement, or at least signaling to the other party that you mean business, in which case you may want to file a relatively lengthy request for arbitration that shows all of your good documents and goes through them in detail. It may be that you want to file a shorter request for arbitration because you want to show that the case is simple and it turns simply on a legal issue. The request for arbitration is an exercise in advocacy, ultimately, at the end of the day, but you don't want to say everything. So it's important, I think, to keep certain points for later and not provide your entire case at the beginning. And I think the same goes for the answer. You have sort of two approaches that you might want to take. One would be a point-by-point response of each and everything that's said in the request for arbitration. And the second would be a more high-level response that tells an opposing story or provides a simple reason why the claims should fail without going into each and every detail that has been mentioned in the request for arbitration. And lastly, I think there was a question about whether it's necessary to put forward a specific figure on quantum in the request for arbitration or the initial pleading. And the answer, in my view, is certainly no. It could help to have it certainly does help to have an idea of what that figure is, in particular, where your case is something like an investor state arbitration, where or any other case, for a commercial case for that matter, where the specific quantum may not be an obvious one. You're not just claiming for invoices that haven't been paid, but some sort of lost profits or enterprise value of a company or a business or something like that. You will want to know exactly how much you are going to be claiming on the merits, although it's not necessary to put forward a figure in the first instance.
Okay, thanks, Alexander. Any comments and questions? Anna?
Yes, on the quantum, I would only perhaps to add to what Alex said. I agree. The only thing is that for the request for arbitration, and if there are counterclaims by the respondent, then the institution will request the parties specify the amount in dispute. So there will have to be some indication of quantum. Obviously, not all details about it, perhaps because it's too early, depending on the case, but the institution, if it's an institutional arbitration, then the institution will require that, because that defines, obviously, as you know, the arbitration costs and the advances on costs that will be requested from the parties.
Thanks, Anna. Anybody want to comment further? We have one question we can attend to, we can deal with from our attendees. But if anyone wants to make a further comment, please do. Mohammed Hasib Mohyuddin Khan asks, in Article 3 of the ICC rules, the parties present an agreement to arbitrate with an asymmetrical clause. Does that clause devolve onto the request to arbitrate? And if the request, does it stretch also to Article 16, where the parties are allowed to make further claims under the rider document? So do you generally advise dealing with issues in relation to asymmetrical arbitration clauses in the request itself? For example, whether they're valid at all. Should that be something you'd attend to right at the outset, Alexander?
I think you certainly should raise any jurisdictional or admissibility objections in the answer, most likely, but also in the request for arbitration if you're anticipating obvious points that the other side will have to say. You may not have the opportunity to do so by way of a response to the answer. And it's certainly a point that the tribunal will want to know about, because it will affect the way the tribunal will think about, at least, the procedure in the arbitration.
Yeah, thank you. Should we move on to the next issue, or is there something more someone would like to say? Okay, next issue is going to be led by Agis, and it is the first substantive pleadings. Agis, please.
So the main starting point here is that by the time we need to start drafting these pleadings, at least for the main issues, it should be clear what is admitted and what is contested, because we've already had the request, the answer, and if we're in SEC proceedings or in other proceedings using the terms of reference, we also have the benefit of that document. So more or less, the picture has become relatively clear, and we know the main positions of all the involved parties. Now, I've made a comment about this earlier, but I should probably say a bit more right now, which is that also by this time, we should have decided on what form the pleadings should take. If they are to be pleadings in the common law style or memorials, if evidence is to be attached or will follow. So these are matters that hopefully will be clear by the time we start drafting the first substantial pleading. Another issue, which is another question which comes to mind, is whether pleadings should reflect the pleadings that we use in the court proceedings in our jurisdiction. The answer is usually no, in the sense that we do follow the intelligence that has led to the development of the various civil procedure rules in respect of drafting pleadings. But when we are dealing with truly international cases, we need to probably adapt the way we draft pleadings so that it meets the requirements of the particular case and is devoid of probably the unnecessary technicalities which are of no relevance in arbitration. Irrespective of what style we end up following, the pleadings must be sufficiently particularized. This is, of course, to the benefit of all the all involved in the case, because it does not allow the case to derail at the hearing. It must be sufficiently particularized so that both parties know what the case is, but also to set the track for the evidence to flow during the hearing. Otherwise, we may end up with a very long, protracted hearing where new issues or ambiguous issues arise, which make it very difficult for the other party to respond to adequately and fairly, and also very difficult for the tribunal to tell what it is that it has to decide at the end of the day. Just a note there that even if when we do particularize, drafting can sometimes conceal more than it reveals. Drafting is a form of art, at least in the common law world. It is considered to be a very artistic exercise, and it can conceal a lot. So we need to be able to maneuver around those traps that may be laid by the other party when drafting their pleadings. And by responding, I mean by probably asking for a clarification or by triggering a clarification with our own pleading. In any case, flexibility is key. No two cases are the same, so it is good to think about how agreeing on some basic principles about pleadings can add to the economy and fairness of the proceedings. And wherever possible, I mean, we can agree to this at the early stages, probably at the time of the procedural order following the CMC, allow both parties to benefit from that. A final point before I move to the statement of claim in particular is that we need to use simple language. This is not a matter of style or personal preference. It is, I would say, it's a cardinal rule of drafting that we must use plain language. We should not assume that other people will be taking up dictionaries and looking up difficult words or expressions which may only be understood by people with our own backgrounds. We should use simple language, and we should never assume that allow the other party to assume or infer on the facts or the law. Everything must be clear, must be put down in distinct paragraphs, short phrases, and with use of as simple language as possible. Now, turning to the statement of claim, which is the first substantial pleading to be filed. It is, of course, necessary to identify clearly all the issues, and we should not forget that the purpose of this pleading is to show the tribunal and the other party what to expect at the hearing. So one must first look at what has been pleaded before. One must start by looking at the request and the answer to the request for arbitration and possibly the terms of reference to see what is admitted and what remains contested. So when the statement of claim is drafted, we should obviously spend a lot more time and length at dealing with the contested matters and not repeat or produce unnecessary evidence on matters which have been admitted. As to the contested matters, it is important that we look at what the causes of action are that we are raising and what remedies we are claiming, and make sure that all the elements are there, because if something is missing, then maybe, at least in some jurisdictions, maybe that will be fatal to some of our claims. We should also take care to draft the statement of claim in a way that is in line with what has been hopefully cleared as the tribunal's jurisdiction by that time. Because if we try to include claims which are not covered by the tribunal's jurisdiction, then they will probably fail as well at an early stage. Now, a difficult question to trouble us at this stage is whether we preempt the other side's defenses. That is a strategic decision to be taken. By that time, we have at least an idea of what the main points of the other side is. So what do we do? Do we embark on answering every single point that we anticipate that as a defense that may be raised by the other side? Well, the answer is probably no, because that's not the right time to do it. It may be a good idea to preempt certain basic defenses if that will add to the economy of the case. But generally, it is not the right time, and it is probably a wrong tactic to do it at the time of preparing the statement of claim for many reasons. First of all, because we may end up wasting time and expense in defenses that may not be actually referred to in the defense by the other party. But we may also allow the other party to maneuver by adopting a different approach to its case than that we anticipated at the beginning. And it also depends on how many rounds of pleadings have been agreed. And because if there are just 2 rounds of pleadings, or usually just a statement of claim, a defense, and then a response to the defense, then it may be a good tactic to try to include as much as we can in the statement of claim. But if there are multiple rounds agreed, then it is probably going to be less pushing for us to include everything there. Similarly, with a defense, again, identify clearly all the issues that are to be raised. All the elements of our defense must be there. Again, the purpose of the defense is to allow the other party and the tribunal to know what to expect at the hearing. Again, all the effort should be put in arguing about contested matters and not admitted matters. Admitted matters in most jurisdictions are very easily disposed of just by accepting the other side's position. And again, we have to look at jurisdiction and whether we have included everything and that we have not included matters that fall outside the jurisdiction of the tribunal, and take into account what further rounds are expected. Now, all these in respect of both pleadings, both the statement of claim and the defense, if this is the agreement of the parties, must be supported by evidence. It is probably more often the case that we agree on this in arbitration, in the sense that we do not file the pleadings and then submit the evidence at a later stage. We usually do it at the same time. So we need to make sure that there is a proper referencing in our pleading to the appropriate relevant witness statements or expert reports or other documents which are presented with the pleading, so that we make the case. It is usually the time when we realize what are the weaknesses and strengths of our case as well, because when we do this exercise, we sometimes find out that there are points which we may have not thought about before, or that are not as strong as we thought beforehand. So it is a good time to reevaluate the case, see how we can improve our position, and if that is not possible, then maybe embark on settlement proceedings. Thank you.
Thanks, Agis. We are short on time, and I would therefore propose that we move right into Agis's next topic, which is the second and further rounds of pre-hearing pleadings.
Well, okay. Well, this basically is moving on from the previous topic. It's a continuation of the previous topic. Again, practice varies significantly. There are huge differences in approaches between common and civil jurisdictions, but there's also a very different practice between commercial and investment cases. In the sense that in a common law case with a commercial context, the pleadings would probably be a lot less. In a case with civil lawyers involved, and especially if it's an investment case, we may have 3 or even 4 rounds of pleading sometimes. Both are right. I mean, it's there is no right or wrong here. It's just a matter of finding what's appropriate for the case. But it is something that we need to have in mind when we draft how many rounds are left. And it's also something which should trigger us to look into rules that may be relevant. An example that comes to my mind, which is quite important, is the common law rule about pleading estoppel, which provides that estoppel is pleaded as a defense or as a reply. It is not something that you plead in the statement of claim. This may not be the case under the law of France or Switzerland, but it is a very clear rule under English and Cypriot law. So there is a good reason why you have to plead that matter in your second pleading and not the first. Likewise, there may be other matters that we should be taking a closer look at what the applicable rules are before deciding how to plead them. If we have followed the strategic decision to leave things for the second round, again, that is a very dangerous balancing act that we need to undertake there, because if we are seen as abusing the procedure by leaving things to be pleaded at a later stage, this may not impress the tribunal and may entail some consequences, especially in costs, if there are requests to add new evidence or amend pleadings by the other side. So my thought on this is that fair play should be the norm, and fair play most of the time is what impresses the tribunal, not abuse. So by putting our cards on the table from the beginning, at least the basic cards, is the starting point. There may be reasons why we may leave things at a later stage. Of course, the obvious reason is that maybe the procedural rules require us to do so, like the estoppel issue that I've mentioned before. Or it may be that we see that the other party is falling into a trap, and we may just stay quiet and allow them to room to do that to their case. But it is always a balancing act, and the emphasis should be on making the right impression to the tribunal, being supportive to the tribunal's role, and not hijacking that effort. So this is all I have to say, basically, and I'm at your disposal if you have any questions.
Thanks, Agis. Any comments from the other panelists?
I just wanted to say quickly, while you were making your presentation, the pressures of putting all your cards on the table, sometimes that comes from the client as well, who's expecting to see an early full-fledged argument so that they can press in settlement negotiations. that's one consideration to take into account. But it's my experience that usually the fact that there's an arbitration being lodged is sort of enough pressure to go to the settlement table without having to put all of your cards out on the table. It's a strategic matter, really.
It's a good point, Chris. But on the other hand, I mean, we have to be careful not to derail ourselves from the main target, which is to win the case, because often the pressure that comes from the client is not that sophisticated, in the sense that they ask us to include matters or evidence in our pleadings which are not really that helpful. So bombarding the tribunal with unnecessary evidence and allegations in pleadings is never a good tactic.
Okay. Many thanks, Chris, for your question. Thanks, Agis, for your presentation and that complete answer. Let's now move on to our next section, which is Alexander speaking about post-hearing written briefs.
So I think, in certain ways, post-hearing briefs are no different than the first and second round, in that your approach will be focused on the tribunal and providing the information to the tribunal that the tribunal needs to find in your favor. However, there's one very key difference, which is that you'll have all sorts of information from the tribunal about where the tribunal stands on the case. It might not be, a feeling that the tribunal is going to decide one way or the other, but through the questions that the tribunal will have asked during the hearing, and perhaps even other interventions that are not necessarily questions, and through the specific questions that the tribunal may have put to the parties, you'll have a good sense of what the tribunal understands and what the tribunal doesn't. And so those two scenarios that I've discussed, or those two sort of pieces of information, are what should guide the post-hearing brief. And the first question, of course, is whether the tribunal has given you specific directions on the post-hearing brief, notably specific questions that you need to answer. And the tribunal may tell you that they only want answers to those questions. They don't want you to rehash the case. In that case, obviously, you shouldn't disobey the tribunal's instructions. But you want to put those questions in context, particularly if the way that they've been phrased is not necessarily favorable to your case. But even if they are favorable, you want to make sure that the tribunal understands why they get you over the finish line. The tribunal may also ask for questions for the parties to address certain issues or certain questions in the post-hearing brief without necessarily limiting the post-hearing briefs to those questions. And in that case, again, you don't want to rehash the entire case for the tribunal, but you do want to make sure that you explain the relevance of those questions and how they fit, and those issues fit into your case. The tribunal may have also not asked specific questions, but imposed a page limit on the post-hearing briefs, or the tribunal may not have imposed any sort of page limit and not given any sort of directions at all. In that case, and in any case, I think you want to think about two things. One, be judicious about how much you say in a post-hearing brief, because the point of the post-hearing brief is really to distill all of the evidence into one specific document. The point of the first two rounds of submissions is to put your case out there and explain with the benefit of all of the evidence and develop that evidence through the hearing. But the post-hearing brief, at the stage of the post-hearing brief, the evidence collecting and sharing has stopped, and you want to show why that evidence points in favor of your case. And secondly, you want to have already done at the hearing one very important thing, which is to keep a record of precisely what the tribunal's questions are, and also any other interventions that the tribunal has made. And that will allow you, one, to understand exactly what the tribunal already understands, and on which you don't need to spend additional time. So, for example, in a very complex investor state case, you might have a breach that has many different aspects. And if you understand from the way that the tribunal has asked questions in relation to one of those aspects, for example, that it understands the issue, it understands the underlying administrative or regulatory issues, you don't want to spend a lot of time explaining those. You can simply remind the tribunal of what they are, but your time and effort is better spent on elsewhere. And understanding what that elsewhere is, if you don't have any directions from the tribunal, is why having a record of the questions from the tribunal will help you. This will help you to understand, one, what the tribunal doesn't quite understand yet, or where the tribunal is not on top of all the evidence. And it will also help you understand what the tribunal is interested in hearing more from. It might be that the tribunal is forming a view of the case and believes that certain aspects of the case are more relevant than others, and that might be apparent from the questions that the tribunal is asking at the hearing. So you want to consider those and adapt your pleadings, your post-hearing submission to that. And that's the case even, it's certainly the case that you want to draw, when approaching the post-hearing brief, you don't want to take the same sort of approach you've taken in your prior pleadings. You want to really talk about the hearing and the evidence that was presented at the hearing, and the arguments that were made at the hearing. And I think that's true even if you don't have a hearing with evidence from witnesses, and you only have a hearing with oral argument. In that case, you still want to focus on the hearing and use the post-hearing brief as a launching point to any discussion that is included in the post-hearing brief.
Thanks, Alex. Comments? One thing I didn't do is ask people to speak about cost submissions, and I mean, I could probably summarize it in a couple of words, but if anybody wants to jump in, you're most welcome. Before we move on to Natalia speaking about the request for relief, which is something extremely important. Anybody want to jump in with some comments about cost submissions, just briefly?
I'm happy to just take a quick crack. I think cost submissions, again, really depend on who your audience is. Some tribunals just want a headline figure. Others, in particular, with a more Englishy background, will expect you, the parties, to explain their costs and break down exactly what certain costs have been, on what basis certain costs have been expended. But I think the general approach in international arbitration is quite general, and really only requires a party to put forward a figure and a brief explanation of why that figure is justified.
Thanks.
And why and just a general sort of the legal basis for finding a cost award.
Yeah, absolutely. Yeah. So costs are often very significant in terms of the money, often as a comparative matter vis-a-vis the amount you're claiming in the principal. So yeah, they're important. I think I see Agis wants to say something, so I'm going to pass the floor to Agis.
Yeah, just very quickly to say that it is, I think it's good practice to ask for cost submissions to be handed together with the post-hearing briefs, because there are many reasons to it, but one practical reason for that is that in certain jurisdictions, upon the issuance of the award, the parties, certain deadlines commence, and it is the time when parties will think about whether to seek enforcement or apply for a setting aside. And it is not fair to the parties to add another issue in that troubling time, which is the assessment of costs. So I find it a good practice to ask for, at least when I sit as arbitrator, to ask for parties to submit their cost schedules with their post-hearing briefs or shortly thereafter, so that the issue of costs, where it is possible, it is resolved in the main award.
Yeah, it's a good point. Chris, did you have a comment?
Yes, just a practice tip that, of course, it depends on the tribunal that you're arguing before, as we've stated several times during this webinar. But in terms of evidence for costs, you don't always need to produce the privileged timesheets and the actual billing of the lawyers that you used on the case, depending on the tribunal, of course. But oftentimes, a statement, maybe a sworn statement by the law firm that incurred the cost may be sufficient for you to prove the cost. You know, the amount, of course, whether that's reasonable or not, that's another question. But that you're not, as a party, you're not usually compelled to produce all of the privileged, detailed timesheets of the law firms involved.
Thanks, Chris. Baptiste?
2 points. The first one is sometimes we consider that submission of costs are, the last in the case, so you just can just win them and put just the amount, etc., without much of meat on them. In my experience, there are submissions which are really important to clients because they are the last evidence of what they've actually paid for, and they want to make sure that the tribunal knows that they have invested a great deal of their money into this arbitration, and that it's been done in good faith and for the legitimate defense of their interests. So it means that you'd better be ready to justify to your client which costs you put in and which you do not, and which I'm saying that because sometimes you might think that the envelope you are going to put in the amount you are going to put in your cost submission might be high or whatever, but just remember that those costs have actually been paid by the clients. And so they will want to as much as big an envelope as they have actually paid. The second point is I find it interesting as arbitrator to still have a bit of meat in terms of the history of the procedure and the history of the conduct of the parties in the submission on costs. Because at the end of the day, that's the conduct of the parties is going to be the thing that the tribunal will rely on most to apportion the costs between the parties. But when it's a long case, you don't remember every guerrilla tactic that has been used, every last minute request for extension, etc. So it's good to have that type of section in the submission on cost. And the last point is don't forget to claim, if allowed by the applicable law, don't forget to claim your client's internal costs in the submission on cost, because sometimes your client or some employees of your client have spent quite a lot of time dealing with the case. Unfortunately, you cannot claim for the mental charge of dealing with a case, but at least you can, try to get an amount which adequately covers the amount of time your client has spent dealing with the case, helping you, assisting you with documents, etc.
Thanks, Baptiste. There's so much to say on costs. Nonetheless, we really need to move on to our next topic, which is Natalia on requests for relief. Natalia, please.
Indeed, and the last topic for today, I presume this is the longest webinar of this series so far. And I'll try to be as concise as possible. Requests for relief are foundational for the arbitration process, and in fact, they encapsulate what the party seeks to achieve through its claim. Hence, the importance of the issue as such. It's we are always, as practitioners, happy when the tribunal grants relief which is sought. However, we are equally concerned if we have the situations where the tribunal is not in line with the principles and the concerns about extra and ultra petita to be mentioned. For those attending the webinar who do not know, with ultra petita, we mean the situation where grant exceeds what was requested, and with extra petita we see the situation where grants is outside of the scope of what has been requested. And of course, alignment with these principles is a safeguard in arbitration. Arbitrators who grant reliefs exceeding their boundaries, they risk having their awards set aside. This, of course, underscores the necessity for precision in the formulation of requests for relief to avoid jurisdictional pitfalls. What is the key in drafting requests for relief? First, imperative. We clearly outline what the party expects. Secondly, clear. We include the full and proper legal names of the parties. Third, self-explanatory. We avoid ambiguity or reliance on appendices. And fourth, self-contained, standalone without cross-referencing other sections of pleadings. This is most helpful to have the grant not dependent on any other documents. And for example, the ambiguous request such as order payment as per the contract terms, as opposed to a clear request where you say order the respondent to pay $1 million in damages for breach of Article X of the license agreement contract number 1, dated on 1st September 2020, is of course the concrete request is much better and would not lead to misinterpretation. Next, arbitral tribunals in principles cannot issue awards binding on third parties absent their express consent. However, requests for relief that implicate third-party interest must be drafted with extreme caution. What third parties we could keep in mind when talking about that? Of course, can be different situations, can be affiliates, can be subsidiaries, can be non-signatory stakeholders, can be regulators or governments. And with all that in mind, if arbitration rule permit third parties with a material interest can be joined or consolidated into arbitration to ensure procedural fairness. Issues around types of relief. The choice and articulation of relief does, of course, impact the enforceability and practicality of the award. If we talk about payment relief, we want to specify exact amounts in the currency to avoid disputes over exchange rates. If we talk about declaratory relief, it is always useful where findings of fact may guide future disputes or events. And here, a good example where you want, in case of technology-related dispute, to have your counterparty to declare the use of the patent. Action-based request must be clear and must describe the exact actions sought, including timelines for such actions. Set-offs requests for set-offs must articulate the precise quantum and legal basis. And interest, here we do specify the interest rates calculation method and the periods covered. We have just briefly discussed costs. If we want to cover costs, we have to provide detailed requests for such costs. Next are residual requests for relief. Often framed as such other relief as the tribunal may deem just and proper. And indeed, they play a big role in arbitration. While they provide flexibility and a safety for unforeseen circumstances, they simultaneously require very careful framing to avoid ambiguity or overreach. And residual requests, they serve multiple purposes. We can talk about flexibility. Such requests act as a catch-all provision for relief that the claimant may not have anticipated at the time of drafting, but which become relevant during proceedings. It's jurisdiction, judicial discretion. They empower the tribunal to avoid remedies that may not have been explicitly stated, but are necessary to resolve the dispute comprehensively. And moreover, by including a residual request, parties can address potential gaps in their primary or alternative relief formulations. Residual requests must respect the tribunal's jurisdiction and the applicable legal framework. And while broad, such clauses cannot authorize the tribunal to grant relief entirely unrelated to the dispute or beyond the scope of the arbitration agreement. And basically all that, it's about the principle of procedural fairness. And of course, residual requests may face several challenges. Poorly framed residual requests can lead to the risk of enforcement challenges due to ambiguity. Opposing parties may argue that a broad residual request denies them the opportunity to address specific claims and state that there is procedural unfairness. And finally, the relief could be seen as exceeding the tribunal's mandate, and then you will face the hesitation from the tribunal side. To maximize the utility of residual requests while minimizing related risks, we may consider the following. We may clearly state that the residual request, residual relief request aligns with the governing law or procedural rules, and make sure that the opposing party has had an opportunity to respond to any claims that may fall under the residual request in the course of the proceedings. With this in mind, we have already covered quite a lot of issues, but I would like to say a couple of words about dismissal of other parties' requests for relief and about modification of requests for relief. First, about dismissals. In responding to claims requesting the dismissal of opposing relief should not be overlooked. This ensures the tribunal addresses the respondent's perspective explicitly and prevents arguments of partial omission. Requests for dismissal serve two main essential purposes. First, it's clarity in the award to be enforced, which means they ensure that the tribunal explicitly addresses and resolves all claims, avoiding ambiguity that could lead to enforcement challenges. And secondly, finality of dispute resolution process, which means that explicit dismissal of claims reduces the likelihood of future litigation or arbitration on the same issues. Key legal framework is ancestral rules, Article 34, which requires tribunals to address all claims and defenses. And to maximize the effectiveness, dismissal requests should be first explicit and clear, which means we do articulate the specific claims or requests of the opposing party that are to be dismissed. And second, supported by evidence and argumentation, which means detailed rationale based on evidence and legal principles to justify the dismissal is provided. When formulating requests for dismissal, parties should anticipate, of course, counter-arguments, potential objections from the opposing party. Without that, does not make sense. A couple of words about modifying requests for relief. The modification of request must balance procedural flexibility with fairness. Again, when dealing with the request for relief, may have a need to modify for several reasons. It's change in evidence, new facts, evidence may lead to a need to adjust the relief sought. Change in circumstances, various economic, legal, other shifts may alter the priorities or strategy. Strategic changes, very important. You receive different background from the client, and or you learned about a change in the regulatory framework in one of the countries concerned, and you have to address all those issues. And modifications to requests for relief in such circumstances are very, very helpful and needed. The tribunal may approve or reject, grant or reject request for modification, but it depends on many circumstances. We know the cases where the tribunal rejects last-minute modifications, but when the modifications are made a little bit in advance, you still may get them granted. Modifying requests for relief can also have several difficulties. First, as mentioned, timing. Late-stage modifications can delay proceedings and lead to allegations of procedural abuse. The opposition from counterparties and substantive changes to the scope of relief may raise questions about the tribunal's jurisdiction. And especially this is important if they extend beyond the original arbitration agreement. In conclusion, the art of drafting requests for relief is a delicate legal strategy. And we might revert on to this subject on further webinars, I guess. Thank you very much.
Thank you, Natalia. Yes, we will revert to it. It's a very important topic, what to ask for, how to ask for it. A lot of it has been covered in a very efficient way by Natalia, so we are grateful. Anna, you have a comment.
Yes,
Yeah.
thank you, Philip. Yes, just a few comments. Natalia referred very well to action-based requests for relief, such as specific performance. One should exercise caution when including a specific performance claim in the prayers for relief, because with the passage of time, the specific performance may become very difficult or impossible to achieve. There is a decision by the Hong Kong courts that were stating that they were unable to enforce that specific part of the award, ordering specific performance, because due to corporate restructure, it was impossible to do it, and they couldn't adjust or change the terms of the awards. On the point of residual requests or catch-all prayers for relief, one should be very careful when including this, such as there was a case before the Swiss Federal Court where a party requested a specific compensation and indicating local currency, and then it added alternatively with such other sum as the tribunal deems fit. The tribunal granted damages in US dollars. And then there was a problem. The party wasn't happy, but then the Swiss courts enforced anyway, because there was an alternative, a catch-all sort of framing of the prayer for relief. And finally, on the point of punitive damages, one has to distinguish between treaty-based investor-state arbitration and commercial arbitration. In public international law, punitive damages are not allowed. I mean, only compensation, it cannot be punitive. This is something of public international law. So watch out when one is dealing with the investor-state treaty-based arbitration. Whereas in commercial arbitration, that could be possible, but it depends on the lex arbitrii and the law applicable to the case, and plus the agreement of the parties. French law, for instance, doesn't recognize punitive damages, whereas Brazilian law or Mexican law, they do recognize. So one should be very careful when drafting this type of request. Thank you.
Many thanks, Anna. Indeed, those are all crucial points. And as Natalia says, yes, there's so much to say. We do need to select. I notice the clock. Thank you so much to our participants, for our speakers, for your excellent contributions on this very concrete and useful topic. There'll be a recording for everybody to refer to, especially people in North America who are still abed and can't join us. We'll post it on the European branch of the Chartered Institute. I thank our participants for your presence here and for your loyalty to our 2 webinar series. The next installment of the other webinar series is on the 17th of December. That's the one on comparative arbitration law. And that particular webinar is going to be on the practice relating to oral hearings, 17th of December, run by Casper Gamelgaard. And the next installment of this webinar series, which is, as you know, on the fundamentals of counsel practice, is going to be after the holidays on interim measures, Tuesday, 14th of January. So with that, I will wish you all a very good day or evening, and we look forward to seeing you again. Thank you all.